Good morning. Thank you very much for joining us today on the first of our quarterly legal updates for letting agents. We've had over 1,400 people register, so the room will fill over the next few minutes. But as we've got a huge amount to crack through, we're going to get going. So our first quarterly legal update, it's kicking off with Q2, but with someone who has been with us many times before, and I'll ask him to introduce himself in a moment. The usual disclaimer today is for general information purposes only. It is not and should not be construed as legal advice or official guidance, although our guest, I'm sure if you wanted specific legal advice, would be very happy to take an instruction from you, and you'll receive his contact details at the end of the webinar. And with that, over to you, David. Would you mind introducing yourself?
Oh, I was waiting for this esteemed guest to turn up. Apparently apparently I'm esteemed. Apparently I'm a partner at JMW Solicitors, and I've been around the block a bit on landlord and tenant law, shall we say, and I'm alleged to know a thing or two about it, or at the very least, I'm a flagrant self-promotionist who's very good at making people think I know a little bit about it. So you take your pick.
I suspect over the next 57 minutes, you'll see that that is false modesty, and we're about to be astounded by your insights.
You can judge for yourselves the next hour as to how much I know.
So today, the running agenda is we're going to have a case update on Northwood Solihull, and also take a dive into electronic signatures. We're then going to go on to the electrical safety standards, so what's happening in practice and what the challenges are, the Renters Reform Bill, CMP and E-money Institutions, Coronavirus Act, particularly looking at possession claims, and then going to audience questions. For everyone who has already submitted a question in advance, thank you very much. If you would like to do so for any future webinars, please email research@fixedflow.com. And so into the first topic, Northwood Solihull. Could you please give us the background to the Northwood Solihull case? What points of law were both sides arguing?
Okay, so just to dial back again, if you're a company, so a limited company or a limited liability partnership, and you want to sign something on behalf of your company, you must comply with the Companies Act. And that basically means that a director must sign the document in front of a witness, or two directors must sign it, or the director of the company secretary must sign it. Now that applies obviously to contracts and things like that you want to bind the company. What has never been wholly clear is what that means for various statutory notices. Now, it has been the case that for long lease property notices, they do have to be signed in that way. What Northwood Solihull deals with is the signing of Section 8 notices by a landlord's agent who happens to be a company, or by a landlord who happens to be a company, and also the signing of prescribed information for tenancy deposit protection purposes by a landlord who happens to be a company, or a landlord's agent who happens to be a company. So Northwood Solihull run a rent-to-rent scheme, so they operate as a landlord and they are a company. So basically they had signed the prescribed information, and what had actually happened is one director had signed it without any witnesses at all. So he'd signed it essentially in his as an individual, on behalf of the company though, but hadn't therefore complied with the Companies Act. And the same thing had happened with the Section 8 notice. This basically worked its way through the county courts up to the High Court, and in the High Court judge found that due to the way that a Section 8 notice is constructed, it wasn't the same as a long lease notice, and so the individual signature of the director, albeit not complying with the Companies Act, didn't matter, because he could claim to be signing as the agent on behalf of the landlord. And directors are always agents on behalf of companies that they operate for. But contrasting that, the prescribed information certificate is described in the law as a certification. And so the High Court judge held that had to be signed in accordance with the Companies Act. And so the single signature of the director did not suffice. And therefore, the prescribed information hadn't been served. And therefore, the 3 times the deposit penalty, or up to 3 times the deposit penalty, was leviable by the tenants against the landlord. Now, this has all been appealed to the Court of Appeal. So the tenants have appealed the loss of Section 8 because not to put too fine a point in it, they're in rent arrears, and 3 times the deposit penalty is not enough to let them stay in the property. They need the Section 8 notice to be killed off, so they're appealing the Section 8 notice bit. And the landlord or the company is appealing the prescribed information bit. So both halves are being appealed by the peeps who lost those bits, and we are waiting currently for the Court of Appeal to grant permission on one or both of those things. I would hazard they'd probably go with both, because the High Court decision is a bit of a mess. The High Court judge didn't properly understand, or wasn't properly taken to how the Deregulation Act altered the Housing Act 2004, and he didn't realize that effectively is backdated. So the Deregulation Act changes were always backdated all the way back to the start, and they basically said that agents can sign on behalf of landlords. So that part of his decision is just plainly wrong. And if you're going to go for half of it, the Court of Appeal will probably just hear the whole thing anyway. And then the High Court judge kind of got himself very tied up in the Companies Act and sort of didn't really address agency aspects of the matter at all. So you've got a lot of really complex law around this. The Deregulation Act says that an initial agent can sign on the landlord's behalf. So one of the arguments that you might choose to make is, well, if an individual signs, even if they're working for a corporate entity, then that individual is the agent of the landlord. But as against that, of course, if the corporate entity has taken the deposit, are they not surely the initial agent for the purpose of the deposit protection? And if I was to say if any employee could sign, then technically anyone off the street could sign on behalf of the landlord. Now, of course, that doesn't necessarily matter, because if the landlord is ratifying that decision, they're simply saying, well, I agree that everything in the certificate is true. And if it isn't true, then they face the consequences of not having properly protected the deposit anyway. So it kind of may not matter that much. It's kind of a we can go on about this for ages.
So a very large number of issues at stake,
Sure.
And a likely successful appeal to be heard in the Court of Appeal, being appealed by both sides. So to summarize it for the people who are attending today's webinar, what does that actually mean for existing and new tenancies in England and the rest of the UK as at today?
As things currently stand, if you are an agent or a landlord operating as a corporate entity, then you must sign the prescribed information in accordance with the Companies Act, i.e. with a director before a witness. If you don't, you're taking a risk. It may be ultimately that the Court of Appeal will bail you out, but up until that point, it is risky. You could, I have proposed, and you can obtain through other sources, a clause to insert in your terms of business where the landlord appoints all staff members of an agent as their agents for the purposes of signing the deposit certificate. That would probably work. But obviously I can't offer guarantees in respect of that, but that would be likely to resolve the problem by just making an explicit appointment. So that kind of...
Very, very useful. Thank you, David.
Lots of questions have popped
yes,
up.
and just as a reminder, we do welcome your questions. We've got time allotted at the end of the webinar, the final 15 minutes for Q&A. So please do submit your questions via the Q&A panel. And also please take a moment at the end of the webinar to provide feedback so we know if we're on the right track with this new quarterly legal update series. I'd just like to sort of take you off on a slight tangent here, if that's okay, which is electronic signatures. And everybody watching this webinar will receive your guide as part of the follow-up materials. But could you possibly summarize use of electronic signatures in agency and any of the potential pitfalls that you see in practice?
Yeah, I mean, electronic signatures is a really interesting area. One of the things that I think is really interesting about lockdown, of course, is it's completely transformed electronic signatures from being something that was mostly done by student-lets and a few sort of agents. You know, it was done by the build-to-rent sector a bit, and people who were a bit forward-thinking, but most people were a bit about it. And now it's become de rigueur, and everyone's electronically signing everything, which is not a problem. I mean, the first thing to say is that electronic signatures are, as a matter of law, perfectly acceptable in the United Kingdom. And the Law Commission has said this, and the courts have said this pretty explicitly now. So I don't think that's an issue. Where it gets squirrely is what you're allowed to use. So the first thing to bear in mind is that You can use anything for an electronic signature. You don't need to use a platform. So various platforms exist by various suppliers. They're not required. An electronic signature can simply be me signing a document with wet ink, taking a photo of it and scanning it back to you. Equally, I could type my name into a document using Microsoft Word and email it back to you. That is a valid signature. I could send you an email saying, I've read the attached contract and I'm happy to agree with it. Thank you very much. That is a valid electronic signature for a simple contract. The issues are sort of smaller than many people think. Where it goes horribly complicated is to do with deeds. And also, of course, having just talked about Northwood Solihull, situations where you need to sign stuff in front of a witness. So they are difficult during using digital signatures. It is not possible to digitally sign a deed in the way that many people will think that you can do it, because your witness must be physically present and actually see you sign the document. So if you're going to use a digital signature for a deed, then your witness is going to have to be around about here, over your shoulder, peering at you while you sign it, and which kind of obviates to some extent the value of digitally signaturizing things. And of course, the challenge from an agent's perspective is, how do you know that they did it? And then the other big ticket item I think that people aren't really addressing with digital signatures is the I didn't sign this defense that comes up every so often. If you email somebody a document for them to digitally sign, how do you know that they actually signed it? Someone else might have opened their email and applied a signature, and they might legitimately turn around later and say, I knew nothing about this. I was subject to fraud. Someone else was accessing my emails and did the whole thing without me knowing. So most digital signing products, and this is where I think they really are worth considering, offer some form of what we call two-factor authentication, where there is some other thing that you have to give. So they have to type in their date of birth, which you've told the software, or you give them a code number, which you send by an alternative means by texting it to them, which they have to put in to verify that they are really the person that you thought they were. In those cases, I think it's worth it, but that has to be turned on. It's a standard feature set that people have to turn them on to do it, and many people don't. And if you don't do it, you might as well not bother, really.
Okay. Thank you very much. Over 20 questions so far. Please keep them coming, and we're going to keep moving through the agenda. So the next up is, it's been over a month now since the new electrical safety standard regulations came out. I say over, we're not quite in May. Nearly a month. How have the industry and local authorities responded to the change? And as a sort of second part to that, to your knowledge, have any landlords or agents been found in breach of the regulations since they came into force?
No, I'm not aware of that. I mean, the first thing to point out is that agents don't actually have to comply with the regulations. So an agent can't be in breach of the electrical safety regulations. It's a landlord's obligation. That's not to say that some local authority won't try and hold an agent liable, but I don't see any basis on which they can. That said, obviously, if a landlord was held liable and it was your fault, then the landlord may well make a negligence claim against you. I'm not aware of any cases at the moment, but I had heard that from a number of local authorities that they weren't going to be providing any leeway and were going to go after people. I have seen a letter from a local authority to a client of mine who was a landlord suggesting he hadn't complied and asking for copies of certificates. But I wasn't instructed further on that matter, so I don't know where that ended up.
So thank you. And so I sort of just add one point to that, which is, while the obligation is on the landlord, the reputational risk to agents who are, for example, doing a fully managed service, I think it sort of extends beyond the strict legal position, although as this is a legal webinar, maybe we'll leave that one there.
I was going to ask you the answer to this question, really, because at the end of the day, you'll be as likely as I am to see where things are. I mean, my feeling is still that a lot of people have not yet fully complied, and
yes,
and are finding it challenging to do so, and that's an ongoing coronavirus related issue.
It is, and so the challenges have been general business challenges, meaning that compliance with the regulations hasn't moved to the top of their burning issues of things to deal with. That's part of it. The second has been availability of contractors. Cheeky plug here for Fixflow. We've built in 3 national contractor networks for EICRs. So if you're a Fixflow client, you'll be able to access them through the platform. But the sort of synopsis is a lot of people have not fully complied, and I believe some people have not started the process of working their way through their portfolios. Moving on to the next topic, being the Renters Reform Bill. Once I get the slide to update, could you please just give us start with a quick overview of the Renters Reform Bill?
Well, in short, probably not, because nobody knows what the Renters Reform Bill's got in it. There's been a number of different iterations. At one stage, it was starting to look like it was going to be an all singing, all dancing sort of party, as and covering all kinds of wonderful changes to the sector. Then the government produced a consultation when it was first called the Renters Reform Bill and suggested it would be about 2 things, which is getting rid of Section 21 and obviously the side effects of that, and lifetime deposits, and sort of said something about landlord justice, but without really saying what that meant. So then no one really knows what's happened since. It's all gone a bit quiet, but the indications now appear to be that they're stripping out even more and just making it get rid of Section 21. It's going to be as small as possible.
And I sort of guessing some of the questions that will come through immediately now, do you have any steer on timings for when the changes will come into effect?
Oh my lord, no.
No.
I mean, at one stage, of course, this bill was supposed to appear last year. Then there was suggestions it was going to appear in spring, and the housing and homelessness minister, before she left her role in spring, said it was coming imminently. Then the current mood music has been about the autumn, but I can't say that it will be the autumn until that bill in fact appears before Parliament. And the reality is that when you there's always a joke when you're talking to civil servants. There's the phrase the civil service summer or the civil service autumn. A civil service autumn ends approximately 5 days before Christmas. So autumn could easily stretch into November, December. Realistically, that bill's got to pass through Parliament with other stuff going on. So it's got to get timetabled, and parliamentary timetabling is a bit of a challenge right now. It would really depend on how that works out. But I can't see it coming to effect before 2022 at best, and probably late 22. The general statement from civil servants as well, of course, was that it wouldn't apply retrospectively. So it only apply to new tenancies created after it came into effect, and not therefore to stat periodic. So what's unclear is whether it'll be like the Deregulation Act, where it only applies to fully new tenancies, but with a 3-year cutoff date, for example, or whether it's only applying to new stuff, and whether that means it applies to renewals or not. Or whether it's just going to come into effect slap bang on the middle of everything. Last is unlikely, but there are a number of different ways you could do it. The indication at the moment is it will only apply to new tenancies, which I hazard would probably include renewals, but not stat periodics, which leads to its own fascinating scenario, of course, which you might actually have landlords not evicting tenants and keeping tenants on stat periodic tenancies, which are quite rare in the agented sector, in order to preserve the benefit of having a Section 21. So I've heard lots of landlords saying, "Oh, well, I'm going to evict all my tenants and get new tenants if this comes in." It's like, well, no, that'd be the last thing you should do, because if you keep your current tenants, you'll probably be able to keep your Section 21. If you get new tenants, they'll get all the new rights. That would be just crazy.
Hopefully, if there is some progress and we're able to provide some more illumination on what is proposed, we'll be able to cover it off in our Q4 quarterly legal update. A cheeky plug there for the fact this is a series. Moving on to CMP and E-money institutions. So this is this topic has been born out of conversations with agency friends of mine. Some agents have had trouble opening bank accounts to comply with the new client money protection, client money requirements. Is that something that you are coming across? What are the penalties for non-compliance? What can people do?
Yeah, this is a major issue now. I mean, the government had extended time for compliance till April. Ultimately, it's down to the CMP schemes, and they're supposed to now be throwing people out who haven't got the right type of client bank account. Some banks will accept client accounts, some won't. It does appear that if you're a smaller agent, they're much less likely to give you arrangements. Now, the real difficulty about all of this is that e-money institutions, so people like Revolut, things like that, are interested in doing this, but they're no good. You can't have e-money institutions as an acceptable CMP banking arrangement. It has to be with a bank or building society. There is also an option which allows specific providers to offer client money protection services on behalf, so offer client banking on behalf of somebody else. So effectively, another agent would handle your client account to your order, and they would then have a proper client account and be CMP protected. So a couple of people are offering that service, and Arla has a mechanism to allow that, and so do a couple of other CMP providers. But to be honest, what the government should do, in my view, is allow e-money institutions. They could amend the regulations to allow e-money institutions to also offer CMP, and I think you would find one or two some of the e-money institutions would jump onto that in order to attract more business. And e-money institutions are particularly safe because all the money that they hold has to be held in a bank. They're not allowed to trade it or do anything with it. They have to hold all that cash in the bank and then have the same amount of money again lodged with the Bank of England. So the more money they have, the more they have to lodge. So they're a very safe deal in terms of holding money.
Thank you. Going to move on now to the Coronavirus Act. And just as a reminder, please continue to submit your questions. We're over 40 questions that have been logged so far. It looks like David may actually be responding to some
I'm typing answers in between to occasional questions, and only to short ones though, so I apologise.
Okay. Coronavirus Act, notice periods, eviction stays, mediation schemes, cost orders. This is a big topic. What are the current rules on possession proceedings in England, Wales, Scotland, and Northern Ireland?
Okay, well, the first thing to point out is that all of those rules are likely to change at the end of May. So currently we are sitting with three things running at the same time, which is the notice periods on Section 8 and 21 notices, the changing court processes, and the eviction stay. So there's all three of those things all intersect with each other, although of course they're not in any way designed in such a way they do intersect. So longer notice periods for Section 8 and 21 notices are 6 months, of course, for most things in England and also in Wales, with specific exemptions in England for antisocial behaviour, high rent arrears, and a couple of things like that for Section 8 notices, and specific exemptions in Wales only for antisocial behaviour. At the end of May in England, the notice periods expire and we do not know what the government is going to do. They have hinted that they will reduce them. Whether they will in fact do so, I cannot say. And the reality is, as we've seen so far, the regulations are likely to appear like on the 29th or 30th of May. And until then, we're not likely to know for sure what they're going to do. If I was a betting man, which I rarely am because I always seem to get it wrong, I would suggest that the government is likely to reduce the Section 21 and Section 8 notice period. Well, they'd like to reduce the Section 21 notice period, and I could see them trimming it back down to maybe 3 months, which is what it was at the start of COVID. And I think they'll probably either open up more exemptions on Section 8 or trim the notice periods as well. Also at the end of May, we've got the eviction stay expiring. Again, the government could extend it. Again, I don't think we'll know for sure until the very last minute. I think they will. they've said that they won't extend it. I suspect they might a little bit actually, but they might widen the criteria a bit further because it's a bit of a mess, the eviction stay. I mean, if you've got a Section 8 notice with 6 months rent arrears, then you can go through and the eviction stay is you're exempt. If you've gone down the Section 21 route, but you've still got 6 months rent arrears and the court's found you've got 6 months rent arrears, you can't evict tenants. If you've got a non-Housing Act tenancy that falls outside the Housing Act 88, you can't evict tenants. So it seems mad to me that tenants who are basically got high value tenancy because they pay over £100,000 a year in rent are entitled to more protection than your average tenant in the mid-market. That makes no sense to me at all. So I can see them looking, and they've been threatened with judicial review on that. So I think they might decide to ease it. And then the third thing that's ongoing is the new court processes where things like coronavirus notices and slower proceedings because you've got 2 hearings. They are currently set to run to the end of July, and the current mood music from the Master of the Rolls is that they will be extended further into the autumn. So the chances are, as we head into the summer, what you'll be looking at is the current court processes carrying on, and therefore the courts remaining slow for quite some time. But a progressive opening in terms of cutting down notice periods, and if you actually get a court order, increased ease in evicting it, subject, of course, to the fact that there's a massive backlog in the court system. The bailiffs are going to be horribly overloaded, and it's going to be quite difficult. I mean, the rules have changed, and in theory, it's easier to transfer stuff up to the High Court for enforcement, but you've still got to get the paperwork signed by the county court, and signing those papers is deprioritized. And there's all this talk about an eviction surge and a cliff edge, but the reality is the court system can't actually cope with a cliff edge. There can't be a cliff edge if you don't have the resources to process the possession cases. So I don't think there will be. And also, notably, in New Zealand, where they had an eviction stay and then reopened, there was no particular surge of evictions. But my view would remain that people should, wherever possible, try to negotiate settlements with tenants. There's new mediation services being offered now by a number of people. People should think about using those.
So could I just pick up on mediation for a moment? So are you seeing increased use of mediation? What does a typical process look like, or resolution? How is this working in practice as it's come more to the fore over the past few months?
Yeah, I mean, the mediation settlement stuff that's around is not really something that I've been involved with because most of it's done pre-lawyer. So you probably want to ask some of the providers. My understanding is they are seeing some interest in it. Mediation processes can take a wide range of options, but essentially in all cases, what you're talking about is some form of facilitated discussion, either by telephone or Zoom or asynchronously using some chat function with someone who's trained in achieving settlements of disputes. And people don't like them, but the reality is that mediation as a whole enjoys success rates over 70 to 80%. So I'm a big fan of mediation in much of my work, and I've written about it extensively. And from a practical perspective, from a landlord, it's often worth considering, because the reality is that if your tenant hasn't got any money, what is a court judgment for rent arrears getting you? If you can't enforce it against anything, it's not terribly productive. You might be better off to come to an arrangement with the tenant whereby they leave in a more graceful fashion, potentially more quickly, with you agreeing to waiver some of the rent arrears you probably weren't going to collect anyway. And everyone moving on, especially if they can't actually continue to afford the property.
It's interesting how the tapering off of the coronavirus rules to prevent possession claims, the ramp back up of the courts and the tapering off of furlough are all going to interplay. And I think the sequencing of that from a policy perspective will be absolutely critical. And I'd just like to jump to another part of this, which is in the mix, which is what's happening with the breathing space regulations.
Okay, I'll get to that. I just want to say one more thing on this. I mean, one thing that's really interesting about the current situation, of course, is it's almost a dress rehearsal for getting rid of Section 21. Because at the moment, there's this idea that having grounds for possession is a quicker route into court in many cases, because you can get shorter notice periods. And the idea of having to mediate disputes and settle things out of court, I think, is something that people really need to get their heads around, because once you get rid of Section 21 and the easy gateway to getting rid of a difficult tenant, the reality is that tenants and landlords who have bad relationships, but they're not bad enough to persuade the courts to evict the tenant, are going to need to find a way to settle these disputes going forward. So I think there's a future for this stuff that we need to start to get our heads around, and people should think about that now. And it's notable that the Welsh government behind the scenes was actually wondering whether it could run on its no Section 21 or longer Section 21 notice periods until 2022, when Renting Homes Wales came into force, and just have a seamless transition into that. They probably can't, they probably won't, but they were thinking about it. And then, of course, as you just indicated, jumping into all this, the breathing space stuff, which I have to say, I think in practice is one of these things where everyone says, oh my God, it would be a nightmare, what a disaster. And I suspect it won't actually come up that much. I'm not sure how many tenants will actually take advantage of breathing spaces. I suspect rather fewer than people think. But in summary, a breathing space allows for a tenant to ask a registered debt advisor to give them a 60-day max breathing space from their debts, during which time those debts that are subject to the breathing space cannot be enforced. So you can't serve a Section 8 notice, you can't go to court. Current court proceedings in respect to those debts will have to stop. And the objective behind that being within that 60-day period, or just after that 60-day period, the tenant will enter into, or the debtor generally will enter into, some arrangement with their creditors, which runs the whole gamut of friendly arrangements through CVAs and into bankruptcy. Well, bankruptcy is not an arrangement; they'll just enter into bankruptcy. But ideally, is meant to enter into an arrangement with their creditors to pay their debts. And in some ways, this could be better. A lot of tenants, bury their heads in the sand when they go into rent arrears, and the money's never collected. It's a bit of a mess. If there was a situation where there was a mechanism whereby someone was going to help negotiate a deal whereby the tenant stayed in the property and the landlord got the debt paid, or most of the debt paid, I suspect that's probably technically better for everyone except for lawyers, really. And obviously, I'm sure we'll manage. So don't feel bad for us.
I can hear a sigh of relief from across the audience, as lawyers will be okay.
Yeah, I'm sure they're very happy.
I want to jump slightly to something which we discussed but had missed me by, which is the local government ombudsman decision on local authorities refusing to rehouse tenants until they're evicted. I think this is, I'm not sure that I've seen it in the trade press, but it sounds like a pretty important decision. Are you able to just sort of outline what that means?
Yeah, I mean, it's quite an interesting little sort of aside. So there is actually guidance on how local authorities are supposed to deal with homelessness decisions, particularly after the Homelessness Reduction Act. I can never remember the name of that one. So essentially, people who've been served with notices are supposed to be threatened with homelessness, and local authorities are supposed to engage with at the earliest opportunity and draw up a case plan for how they then proceed. And they're supposed to get in touch with the landlord, and they're supposed to maintain contact. Once a possession order has been obtained, a local authority is then supposed to look to rehouse, and it is unlikely to be acceptable to wait until the bailiff the bailiff appointment turns up before rehousing a tenant. So they're being pushed to do it a bit earlier. And throughout all of this, the local authority is supposed to keep in touch with the landlord. So it's perfectly acceptable for a local authority, as happened in this particular case, to say to a tenant what their rights are, i.e. you don't have to leave until the bailiff turns up, which is true. What is not acceptable is for a local authority to say, we won't rehouse you until the bailiff turns up. And the other thing that's not acceptable is for a local authority to simply say that to the tenant once and then wash their hands of it until the tenant comes back later. So the local authority in this case told the tenant their rights, but then didn't keep in touch with the situation and sort of washed their hands of it a little bit until the tenant came back with a bailiff's appointment. And this obviously cost the landlord money, which he complained about, and was a breach of the guidance, which he complained about. So So basically, the summary is that local authorities should be getting in touch with landlords quite early in the process where a tenant is presented to them, and then they should maintain touch. So landlords who are contacted by local authorities, one should be keeping the local authority up to date with the progress of the situation, and also pressing the local authority to say what they're doing and what the rehousing plan is for the tenant if there's no option for them to stay.
Thank you. So a very large number of questions, and my colleague Remy is working behind the scenes to consolidate.
I've been casually answering a few.
Okay. So hopefully the answered ones, the response has been helpful. I'm going to start with a really broad one, which I think encompasses quite a lot of the questions that have been asked. What are the requirements then in terms of signing prescribed information? So could you summarize that, please? Because I think that covers probably about 10 of the questions.
Sure. So the prescribed information has one of the elements of the prescribed information is a certification signed by the landlord that everything they've said is true. That needs to be signed by the landlord or on the landlord's behalf by the landlord's agent. If the landlord is signing it themselves and they're not a company, they can sign it. If they're a company, they must sign it in accordance with the Companies Act, in my view, which means they need to get a witness or two directors or the various options. If the agent's signing it and the agent is a company or a limited liability partnership, they will need to comply with the Companies Act, which means a director signing it before a witness, subject to obviously the Court of Appeal decision, which might change that. The tenant has to be given the opportunity to countersign the prescribed information, but they are under no obligation to, in fact, sign it. So a lot of people get very upset about whether tenants sign the PI or not. The tenant must be given an opportunity to sign it, but they're not obliged to sign it.
Excellent, thank you. I'm now going to pick up some of the permutations through the questions.
Okay.
So the second level of question is, if a company or in fact an LLP actually has granted delegated authority in an appropriate mechanism to an employee, can they sign by themselves? Should we take them one at a time?
I would say so. The High Court was abundantly unclear on this point, which is one of the reasons why its decision's not very good. But one of the things that was likely to be canvassed in the Court of Appeal is exactly that point. I mean, yeah, in my view, yes, absolutely.
There were a few questions around partnerships, which I'm going to assume for this purpose is a limited liability partnership. I mean,
LLPs are bound by the Companies Act. There's no difference. So that would mean two partners or one partner before a witness. If it's a simple partnership, i.e. a non-LLP partnership, then it will depend on the partnership deed.
And a sole trader.
Sole traders are just people who are just calling themselves something, so they can just sign.
Excellent, thank you. I've slightly lost my place on the questions. Can a document, let's call it a tenancy agreement, and a document of some description be signed electronically by one party and wet signed by the other party?
Yeah, sure. A digital signature is just like any other signature. So there's no reason whatsoever why you can't mix and match.
And if doing things through counterparts, so different people signing different documents, is it a requirement or simply best practice to have a counterparts clause, do you think?
It's good practice. It's not a requirement at all, no. The courts are a bit smarter than that. They don't really need you to write it down.
I've got a good, but I suspect very hard question. If you were to speculate and wanted to, we can move on from this. What do you think the outcome of the Court of Appeal case for Northwood Solihull will be? Assuming that,
given I'm doing it on a no-win, no-fee basis, I think you can safely assume I'm reasonably confident I'm going to win.
I suspect we may come back to some of the other questions on that if time allows. On EICR, so the synopsis that you gave previously was that the liability rests with the landlord, although the agent may have secondary liability to the landlord if they had an obligation to, if they're taking on a contractual obligation to the landlord. A couple of questions have come in. Do you think that obligation would extend to a non-managed service? And secondly, what, if anything, should agents be looking at in their terms of business, or looking to change in their terms of business to make it clear as to whether or not they would have that liability to landlords?
Well, to answer the first question, the answer to that is the second question, really. It depends what you've contracted to provide as part of your non-managed service. I mean, in general terms, if an agent hasn't fairly explicitly said they're going to do it, then I think it'd be hard for a landlord to claim that was part of their service. Generally, agency law works on the basis that if you have obligations to do stuff, then those need to be set out. If there's a generic obligation to manage a property in accordance with the law, then that could capture it. But very few people write their agency agreements that way. In terms of changes to your terms of business, you just need to make sure your service provision sets out what your position is on EICRs. I suspect. I mean, I suppose most people will probably have them very similar to GSCs. If you want a quick and dirty alteration, alter your GSC clause to say GSC and EICR.
Some questions have been asked around inability to gain access to a property for carrying out an EICR. We separately carried out a webinar, I believe, on this, and may also have written a fact sheet.
There is a superb fact sheet, I'm sure, about this, but yeah, this is a problem because the regulations are terribly poorly written in this area, and the government guidance is just wrong actually about this. So technically, in the regulations, there is no exemption or get out of jail free card if the tenant won't let you in to do it. And that's the same as GSCs, actually. If you've been served with a remediation notice by the local authority, so the local authority has come along and said, you haven't done this, or you've had a fail, and the local authority then tells you to sort it, then there's an exemption on a remediation notice that you can't get in to do the work. But there's no exemption on the basic existing in the prior obligation to actually have got the notice in the first place. Now, the MHCLG has said to local authorities in guidance that they expect them to be reasonable about this. But obviously that's their discretion, and reasonableness is a hugely variable feast in my experience. On gas safety certificates, the health and safety executive has indicated in their prosecution guidance that they won't go after people who have made at least 3 genuine attempts to get in different mechanisms. I would try to do the same thing on an EICR. I mean, ultimately, you would have to consider whether it would be appropriate to try and use Section 8 Ground 14 for eviction or threaten an injunction.
Thank you. And it's not just having tried to gain access. I think documentary evidence is key. So please do keep full records of communications requesting access and effectively an audit history of what happened. But for anyone who missed our previous webinar, shame on you, but we would love to provide you with a copy of the guide. So if you send an email to research@fixo.com, or at the end of the webinar, there's an opportunity to provide feedback. Just put in something like I'd like a copy of the fact sheet, and we will send you a link to be able to access that. A couple of questions there on PAT testing. So what is the legal position on PAT testing? Are you happy to pick up on that, David?
There is no legal position on PAT testing. You don't have to do it. So it was considered with the EICR regs to include PAT testing. Scotland requires it. But I don't. It's not a requirement here. I think it's a good idea because obviously if something goes wrong with an appliance you've provided to the tenant and they die horribly, then clearly a lack of testing is likely to come back to haunt you. So I think PAT testing is something that people should seriously consider. But I don't think it's something you have to do. No.
This question is probably a little bit too specific, so I want to make it a broader one and go back to CMP. What should people do if a bank or multiple banks refuse to allow a client account because they're concerned about the anti-money laundering processes in place or similar? Or I guess more broadly, what happens if people are really struggling to get client accounts?
Well, I mean, one, swear at the bank a little bit, but I mean, the reality is I don't have an answer. There are alternatives. And there are people in the market offering client account management services where they will manage your client account for you. And at the current time, those would probably be your only option.
Electronic signatures. So a specific question to, I suspect this will be a quick one. Can you use e-signatures on Section 8 and Section 21 notices? Or are there any limits to documents to which you can affix an e-signature in place of a wet ink signature?
In theory, no, actually. And indeed, there is, though I'm not supposed to talk about EU directives, there is an EU directive, but it is actually enshrined in UK law that says that's not the case. So
These
so the short answer to the question is you should be able to use it everywhere. I mean, I would probably do so with caution, and it would depend on exactly how much how important it is to you.
I'm going to jump now to right to rent checks. I appreciate we didn't cover them off, but as there have been some questions, I think it might be useful for the audience. So if we become aware a tenant doesn't have the right to rent before a follow-up check is due, do we have to notify the Home Office as soon as we find out, or is the obligation only triggered on the renewal of the right to rent check?
You're not obliged to notify the Home Office, but I would suggest you do.
And is there any updated guidance about EU right to rent checks after the 30th of June?
When the government issued their guidance on right to rent checks, they indicated that they weren't going to do anything about EU nationals until the new immigration bill, and things would stay as they were. And the new immigration bill is expected sometime next year.
Sorry, I'm just filtering through the questions. There another 40 odd questions have been asked while we've been going through this section, and again, trying to provide as much value as we can to the audience. One of the themes is we use a system for our tenancy process. That tenancy system only allows for the signature of one person to sign that document, sign various documents. What ought we do, or what ought our tenancy system provider ought to do?
I certainly think the provider might like to address that point if they can. I mean, it depends on how you perceive the risk. The reality is that I expect the High Court decision to be overturned, although I can't guarantee that in the Court of Appeal. And the difficulty is, of course, if the Court of Appeal in whatever way endorses the High Court decision, everyone's screwed backwards, because there's loads and loads of prescribed informations out there that will be signed wrongly, which means, of course, that the tenants will be able to take 3 times the deposit claims all over the place. There could be thousands of them, tens of thousands of them all over the shop. So if you allow it to continue, there's a risk that the best solution I'm able to offer at the moment, the one I've been suggesting, is that people put a clause in their terms of business saying that the landlord authorizes any employee of the agent to sign the PI on their behalf. That may work.
Thank you. I'm going to call this a random selection of questions, which I think are interesting and hopefully valuable to everyone. If there's a bailiff warrant during the breathing space period, is the bailiff warrant effectively stayed until the end of the breathing space period?
Yeah, you can't enforce a bailiff's warrant on the breathing space. I mean, I should caveat this with, it depends on what the warrant was obtained for. Breathing spaces only relate to debt. So if you've obtained a possession order in respect of Section 21 or for antisocial behaviour under Section 8, you can go right ahead. It's only where a warrant or a court order has been obtained in respect of rent arrears, and those rent arrears are subject to a breathing space. So there's nothing to stop people evicting for other reasons that are not directly connected to those rent arrears. And I should also point out that during the 60-day breathing space, tenants are supposed to pay their rent. It is a requirement of a breathing space that they continue to pay their debts. If they If they don't, you can in principle issue a fresh Section 8 in respect of those specific debts.
There's a question which makes a huge amount of sense given what we've discussed today, because we've discussed changing terms of business, which makes sense and is easy to achieve for new clients coming on. How could an agent best amend their terms of business for existing landlord clients to clarify, for example, responsibilities around EICRs or any of the other items that we've covered off?
And if you've got a decent terms of business, it'll have a clause in it that allows you to amend your terms of business with on notice to existing clients, and you need to take advantage of that clause and issue a new terms of business to your clients and say, this is our new terms of business.
Next, slightly we're sort of dotting around as these are coming in. Question is, what ought an agent do if the local authority has refused to provide an email address or equivalent? I guess the key might be the word equivalent, to provide information about EICRs that have failed.
Yeah, this makes me laugh, because the idea that local authorities are looking at this stuff that you're sending them, I would just chuck it in the mail to the environmental health department. I mean, they're the responsible people, or email it to a generic environmental health address. But the idea that they're looking at this stuff is laughable. I mean, some local authorities have got piles of these things sitting around already in shelves somewhere. By the time they look at them, the electrics are probably going to have to be sorted.
Thank you. And in terms of evidencing such posting, would you send it by registered post, recorded delivery, or just put it in a letterbox with a photo showing that it had a stamp affixed?
Yeah, I mean, I would probably just email it, frankly, to the generic environmental health email address of the local authority. I mean, if enough people do it, you'll probably find the local authority will rock up an email address pretty quickly, won't they?
Okay, next question is, Wales will go through tenancy reform in 2022 when occupation contracts will replace ASTs. Will this reform affect use of company tenancies?
It shouldn't do, because it only applies to occupation by individuals. That does apply to licenses. So company lets fall outside the remit of the Renting Homes Wales Act.
Okay, thank you. We referred to a form, I think this refers to the delegated authority that we talked about previously. So providing authority for one or a class of employees, perhaps to sign documents on behalf of a company and to bind them. Where might such a clause be available? Or would you suggest perhaps this is an opportunity for agents to get a, what I'll describe as an MOT or health check on their terms of business and general operation processes? How
I have made a clause available through another entity.
Okay.
And I won't say it here because that would be unfair.
Okay.
It's not in competition with Fixlow, I hasten to add, but there are other people I work with, and one of them is providing a clause that I have written. But clearly, I think people should have a health check of their terms of business for sure.
Have you heard of banks requiring separate bank accounts for each landlord client, or is there was only one question on there, so maybe it's anomalous or misunderstanding at branch level?
That is what banks are doing. Basically, the issue here is not with client accounts; it's with pooled client accounts.
Okay.
So some banks are doing what they would do with block management agents because they don't understand the difference, and saying that every single client needs their own individual bank account, and then of course they're doing the KYC on every single one of those individually. But yeah, it's
So some people are now commenting to point out that this seems to be much more widespread than I thought it was, and naming various banks.
It is more widespread because some people have said, "Oh, certain banks are safe."
Yeah.
And that was my thinking as well. But actually, from my understanding, actually, it's not as simple as that. Certain banks are safe if they like your business enough and you're big enough for them to make the effort. It appears to be what we actually have, which is almost even worse, really.
And I'd like to leave you with a future gazing question, which is, what do you think the impact on landlords will be if, as looks likely, Section 21 is abolished?
Wow. Well, I mean, first, that depends on what alternative Section 8 grounds we put in place and how we do it. So the first question is will we have Section 8 grounds for sale, for example? If you don't have a Section 8 ground to allow sale, then that's going to completely alter the market, because landlords will then have to there'll have to be a much bigger market for sale with tenants, which will alter the situation dramatically. The other big question is, are you going to impose obligations on Section 8 like you have on Section 21? I can't serve a Section 21 if I don't have a GSC, if I haven't got an EPC, if I haven't got my deposit sorted. Are you going to port all that stuff across to Section 8? There's a push to do so. In Wales, that is the case. If you don't have a proper registration with Rent Smart Wales, you can't serve a Section 8 notice. So do you port that onto Section 8, or is that really unfair on landlords who've got tenants in massive rent arrears? There's a whole Supreme Court human rights argument just sitting around that one. So there's pressure to port across, but would you do that? And then what will landlords do? I think some will probably walk. Some will be reluctant to walk, having invested in the sector for so long and potentially approaching an age where they want to maintain that asset. So I think the government probably thinks the sector will get smaller and professionalize a bit more and have fewer landlords owning more property. There are indicators of that already during lockdown. In fact, there are some of the early mortgage indicators suggest that landlords are selling to other landlords who are holding larger portfolios. I think landlords will get more selective about tenants. I think there'll be a lot more requests for guarantors and things like that, and which will potentially disadvantage those people at the bottom of the food chain even further. One of the things that I think will be interesting will be to see what landlords do about eviction. It will get more subtle, so landlords will need to be more, agents particularly will need to be thinking much more about different grounds for possession. They're going to have to educate themselves more and be more aware of the need to gather evidence. And then I think landlords and agents will have to try to settle more disputes.
Perhaps to more mediation. David, I'm hugely grateful for you giving up your time and insights and sort of leading the charge on the very first quarterly legal update for letting agents. Thank you very much to everyone who's attended today. Could you please take 30 seconds, or in fact 10 seconds at the end, to provide us with some feedback so we know if we're on the right track, and we will update and iterate as we go for the next webinar in the series. If you'd like to keep up to date with ebooks, guides, content, and webinars from Fixo, please follow us on all of the usual social media channels. If you have any questions, or in fact, if you want access to the EICR flowchart and fact sheet that I mentioned earlier and haven't already got it, please email research@fixo.com or put your feedback in the feedback form at the end. Thank you all very much. I hope you have a wonderful day. Thank you again, David, and look forward to catching up in the next quarterly updates.
No problem, my pleasure.
Thanks. Bye.